Okay, I want to welcome everybody to this month's webinar, the Micklin Law Group, Estate Planning Tips for New Jersey Residents. Before we move forward, I'm going to point you to the panel that's probably on the right side of your screen, the control panel, and go down, I guess, into the chat section or the question section. Somebody just post a comment so I can make sure that everybody can hear and see me. I want to make sure that the audio and visual is going through. You do either in the chat section, which is I think the last tab, or the question section, which is in the middle. Okay, so I see one, I got a comment, so I'm going to go on the assumption that we can see and hear, and let's move along. All right, so let me give you a little background for those that have not attended any of these webinars before. We do these on a monthly basis with different topics. It's generally a 1-hour presentation. Sometimes it's a little longer, sometimes it's a little less. Depends just on the nature of the material, but I do my best to keep it within that time frame, but also to give you a chance to ask questions at the end. It's a one-way communication, so you can see my screen and hear me hopefully throughout the duration, but I can't see or hear you. There is a chat panel where you can post comments like some of you just did for me, and you can ask questions. I ask that you post questions throughout the webinar so that we ensure that we get to them and you don't forget them as we move forward, but I don't stop during the webinar to address them. I like to keep going, then I address them at the end. But I will take as much time as necessary to address any and all questions, so you need not worry about putting up any amount that you have. Just don't expect me to get to them until the end. I also just started to do something different that I haven't in my past webinars, and that is I upload the PowerPoint presentation also. I record these, and I also upload the recordings to my website at some point in time afterwards, so you can always hear it again. And if you want to just make a copy of the PowerPoint, because sometimes they'll have specific information, they'll have statutes and case law, it's there now for your reference also. Now, let me give you a little bit about myself for those that are attending that haven't worked with me in my firm. This is me. My name is Brad Micklin. I'm the managing member of the Micklin Law Group. I am a licensed attorney in New Jersey and in Pennsylvania. I can appear in both state and federal courts. I began my legal career as a judicial law clerk for the Honorable Eugene Austin, who sat in Bergen County, actually currently sits in Bergen County. From there, I went to do complex commercial litigation with Kessler & Associates in Clifton for a few years. I found that while I enjoyed the complex litigation, I didn't care much for representing companies. I like to deal with people. So I transitioned from there in 2001 into my own office, my own practice. I was a solo practitioner at the time, which means I worked by myself and did a little bit of everything. The Micklin Law Group now has several attorneys in addition to me. We have and always have been concentrated in divorce, family law, and estate planning and litigation. I handle more of the high complex, high net worth, and high conflict cases. My associates handle different varieties of levels of litigation. Next, I list a series of awards that I've received or recognitions, not to boast, but I think it's always important for those that are listening to me, whether or not you are working with me or may work with me in the future, or even just to hear my information tonight. You want to know that you're listening to somebody who knows what they're talking about, and I think it's always important. The awards on the left are my more recent ones: American Academy of Trial Attorneys, Top 100 Lawyers. The ones in the middle are client satisfaction ratings. The top one is the AVO rating, 9.7 out of 10. AVO is a large website that has an independent algorithm to review and rate attorneys. You can go to that website, read about our firm also. And the awards on the right are other I get from Martindale Hubbell, which is the largest legal research and database, I think, in the world. And then on the bottom is an award from AVO. That's an old one, actually, because if you notice, the rating was 8.3. That's years ago. It's now the 9.7 that you see in the middle. And like I said, just so you get an idea of who I am and what kind of work and service you can expect to receive from our law firm. So let me go through just the brief elements of what we're going to talk about tonight. Tonight's webinar, the estate planning tips that you need to know, may not be the most exciting of topics compared to some of the other ones that we've dealt with, but it's probably one of the most important. It can be one of the most devastating events to a family to have to take care of a loved one's estate. So it's already a very difficult, challenging time. So if it's not planned properly, it can be very, very devastating for the people that are left behind us. So we're going to talk about 7 broad topics. First is going to be the elements of a will. I'm going to tell you what the form it has to be in. We're going to tell you the requirements, the basic requirements of a will. Give you some information about the witnesses and basically why these requirements exist. Next, we'll talk about the probate process. That's what you do when a person has passed. That's what the court process is called. Tell you how to file that, the requirements, and some of the documents you may need to go through that. Next, we'll talk about probably one of the most important aspects of estate planning, and that is minimizing estate taxes. There are both New Jersey and federal estate taxes. There's also possibly inheritance taxes, and they can be quite expensive to almost any estate, and depending on proper planning. 4, naming somebody to take care of you if you become incapacitated, otherwise known as a living will or medical directive, power of attorney, medical directive, power of attorney. Number 5, ensuring your children's caregiver. We'll talk about provisions that you can and should include for custody of children, both the care for them, the physical child, as well as the money that may be left to him or her. 6, we'll talk about cremation and burial just a little bit because I think it's a topic that many people don't really consider, excuse me, when they're planning their estate. So we'll touch on that to help you out. And lastly, we'll talk about life insurance and how it helps protect your assets in your estate. We'll show you how it's used to help with some of the costs as well as the tax issues that we'll talk about in number 3, and how it all just ultimately goes towards asset protection also. All right, so let's go on to number 1, elements of a will. Now, the elements, there are going to be several general requirements that we'll want to talk about that are very important. The problem is with estate law that it's not so bad now, but the law used to be very rigid, and that is if you had a will and it didn't follow the rigid requirements of the statute, it failed entirely, completely. Now, the law is starting to develop a little bit more to recognize that with the way that documents are sort of mass-produced in programs and everybody has multi-social media, that they're starting to relax the requirements for an incomplete will. But I think it's still important to do your best to comply with the general requirements, so let's take a look at what they are. First, the will has to be written. Now, that may sound like common sense, obvious, but a lot of people have a lot of misconceptions about the law. And one of those that I found is that some people think if you videotape your will that it's better because they can see the person and know that the person's healthy and of sound mind. But that's not acceptable. That's not a valid will. Next, it has to be signed by the person who's making the will, which is another reason why the videotaping is insufficient. Now, there's also some things that we used to call holographic will. There's new terms which I won't go into, where if you wrote out your will or you wrote changes on your will, there's a question of does it revoke the will, or is the writing itself a will? Because some people will scribble notes, unfortunately, on their deathbed quite often. And the law is starting to develop whether or not that would be. There's certain requirements for what used to be called a holographic will. I'm also not going to go into it. It's a little bit beyond the spectrum of this basic program, but it's just important that the writing must be signed by what's called the testator, the person making the will. Now, sometimes people are in a physical state where they're unable to sign. They may be very, very ill, very sick. You are allowed to take their hand and move it for the signature if it's clearly their intention to have that document executed as their last will and testament, but they're physically unable to. You can assist them, and it does not necessarily need to be legible, but it needs to be theirs. The reason that that's okay is that there will be 2 witnesses that will be witnessing the testator's sign. And as I mentioned a moment ago, that he must be of sound mind. That's why you have the witnesses. As long as the signature is of a person that's sound mind, and obviously they have to be 18 to make any kind of contract. So here are your basic requirements. It's got to be in writing. It's got to be signed by the testator who's over 18 and of sound mind. It's got to be witnessed by 2 individuals. The important thing to know about the individuals is that they should be what's considered impartial or disinterested, which generally means that they don't receive anything under the will. The purpose of them signing is so that if there's a challenge to the will, either there's a claim of undue influence or lack of capacity, these witnesses will be the people who are brought in to testify as to the testator's condition at the time of the signing. So they should not be people that would have received something under the will that could give them motive or reason to be less than forthcoming. So here we have the basic requirements. So let's start to talk about why it's critical to have a will. And it's something that I can't stress enough. I can't tell you how many people I come across that don't have wills, that really should and maybe don't even fully appreciate the results of not having one. And it's hopefully what we can impart to you today. So I'm going to sort of move through these a little quickly if possible, because there's a few and I think I don't want to take too much time, but it's important. First, it's you get to decide how your estate is distributed, not the state of New Jersey. Basically, if you do not have a will, there is a law that says what happens to your property. And let me be clear, it does not go to the state. A lot of people come in and they have this belief that if you don't have a will, your property goes to the state. That does not happen. There is a statute that sets forth which of your family members will get it in what order. So your family, your remaining family will always have it. Now, if you happen to be an individual that does not have family left, which it happens from time to time, then it may actually what's called a cheat to the state, which goes to the state. But with a will, obviously that doesn't happen, which is why you want to have it. But if you don't, it still will go to your family. It just may not be the family members that you intend or want to inherit your property. Next is avoids the lengthy probate process, which I told you we'll go through in a few minutes. The probate process itself can take up to a year sometimes. It can take even longer if there are challenges or legal complications. The costs, legal fees and professional fees, can be anywhere from 5 to 10% of the estate, if not more. There's also executor fees, which will be coming out. So there's a lot of costs that go into the probate process. And if you have a proper will, and maybe it's trust planning, which I'm not going to really touch a lot on here, but I have another webinar coming up, I think later next month, to discuss trusts. It helps you avoid these costs. And just having a will avoid the cost, even though it doesn't avoid the probate. It still reduces the complexity of it. Minimizes estate taxes, probably the most important thing to consider. There are 2 forms of estate taxes, like I said at the intro. There's New Jersey estate and there's federal estate. The bigger concern for the average person is your New Jersey estate and not your federal estate. We'll talk about that in a few minutes, but it's just important to know that you should be minimizing your estate planning or your estate taxes if you're planning properly. You choose your fiduciaries. That means the person that handles the estate, that handles your property, that handles the distribution, may even be those that handle custody of your children and their inheritances. If you don't, either somebody has to file papers and ask to be appointed, and sometimes they don't know to do that, or the state then appoints somebody. Usually not what most people would want. You can choose to disinherit people. Like I said a moment ago, I touched upon, sometimes the family members that would receive under the intestate statute are not the ones that you want to inherit. Some people may have a broken relationship with their parent because of a divorce, or their sibling is married and they don't want the wife to inherit anything. These are things that you can specify that somebody does and does not get in your will. And if you don't, the law will determine it and it will go to them regardless of how you might have felt about it. Avoid legal challenges like claims of undue influence, claims of promises to make transfers, and a lot of other issues. It can be a very messy situation when money and family get involved. Having a will helps eliminate that. And last, gives you peace of mind. A lot of people think of estate planning as planning for death. I always say it's really planning for life. It's so that you know what you have and those that you care most about are taken care of. And things we'll talk about a little bit later, like the powers of attorney, medical directives, that also helps in case there becomes an incident or an accident where you're not able to take care of yourself and you need somebody to do that for you. That's already taken care of. planning this gives you the peace of mind of knowing that everything that's important to you, both people and money, are all taken care of. All right, so let's talk about the probate process. The thing about the probate process is initially each county, most counties have varying requirements. So not every county is the same. I'll go through in a second, the basic requirements to begin a probate process, but I usually recommend that you call the surrogate's court in the county where the person passes to find out if they have any specific requirements to follow. Like, for instance, I think Morris County is one of the few that makes you actually physically go in person and file for probate, where others let you just do it by mail or even by email and uploading. But so let's talk about the basics here. So, like I was saying, the fiduciary, which is generally the executor, but fiduciary is just a person, the trusted person involved. File in the county where the decedent resided. Now, that's important because it's not necessarily where they had a residence or real estate, but it's where they were living. And that sometimes may be tricky if they had a home, but maybe went into nursing care and they were there for some time. You need to ascertain where they were considered to be a resident. And then when you go, you need to bring along these 5 things: the original will, which hopefully you'll have, a death certificate, which usually you'd receive by this point in time, the fiduciary's photo ID, whoever's in charge of the estate or trying to probate, the probate application, which I said if you call the court first, you're likely to get the form from them as well as everything else that they would require, and the filing fee, which I unfortunately don't recall what the filing fee is now. I'm fairly certain it's standard throughout all counties, but I don't recall the number, so I apologize for that. If that's important to anybody, let me know and I'll get you the specific information. Now, once you've done all that, this is what you have to do after it. You got to notify all the parties first, and that's with what's called a notice of probate. A notice of probate is a form, and you can probably, if you're doing this on your own, you can probably get it from either the surrogate's court or possibly the internet. And it's a notice that says basically you've been named, I'm probating this estate. If you would like a copy of it, you can write to me. You can attach a copy of it, or you can say if they want a copy, they can give it to you. You have to send it to all the people who either are named in the will that would receive something in the will, or those that could have received. So let's say they're children that were disinherited. You would send them a copy of it even though they're not named in the will, because they have the right to know that they're not in the will because they may have a challenge to that. After that, the fiduciary, the basic requirements to then probate the estate, and I'm really putting into a simple nutshell for you, is first to marshal the assets. So one, you have to gather what they are, find out what they are, both by going through records, collecting mail, talking to family, looking at tax returns. Gather the assets with marshal and probably liquidate them, depending on what the terms of the will say as to what control you have over them and who they go to. But generally, you're going to take and liquidate them. Pay final expenses, which can be funeral expenses. There might be some administrative expenses to the estate, costs like to maintain real estate, taxes, the executor fees, any credit cards and taxes that are outstanding. All these have to be paid first. A lot of people think that you don't have to pay any bills like credit cards, but you do. Then you have to file taxes. Now, you file taxes generally for both the estate itself and the decedent, the person who passed. You file the estate tax returns for the person who passed for the last year that they received income. If they die in the middle of the year, you still have to report whatever income they received, if any. And then you're filing a tax return, if need be, for the estate itself, depending on the value of the assets. And then there's other tasks that will vary depending on the nature and size of the estate. You may have personal property to auction. You might have real estate to list for sale. Various administrative aspects to all of the above that are different from estate to estate. But the most common are auctioning personal property and the sale of real estate. So moving on to what is probably, like I said at the beginning, one of the most important aspects of proper estate planning, which is first why I usually recommend people don't just go online and download a form, because sometimes that's going to do more harm than good. I also recommend that you not rely just on the information I'm giving you tonight, because I'm really giving you just a cursory view. I am not going to be talking about gift taxing or gifting and the gift tax issues. I'm not going to be talking about trusts and how they avoid taxes. So I'm really giving you just a light cursory review. You should either talk with an attorney or an accountant when you're planning your estate. But let's at least look at some of the basics. So let's talk about estate taxes. As I said, there's going to be federal and state, federal and New Jersey. So there are exemptions for your taxes, meaning if you have a certain amount or below that, you don't pay certain estate taxes. The federal limit is for $5,400,000, 5.43. For the average person, that means you're not going to be paying federal estate tax. For a married couple, it's actually 10.8, and for reasons I won't go through, it works as a combination. So the average person that we're going to be talking about is not going to be dealing with federal estate tax. But New Jersey estate tax is a tax over anything that's worth, any estate that has a value greater than $675,000. Now, a lot of people are probably sitting there saying, well, I don't have that much, so I don't have to worry about it. But you would be surprised at how much people have and they often don't realize, because a lot of people first don't realize the value of their estates. And secondly, they don't understand or know what assets are considered estate assets. When I describe the probate process, that's where assets go through a will. Not every asset is a probate asset, but every asset is counted for estate taxes. So you may hear things that people may tell you, well, you don't have to worry about life insurance. It's not a probate asset. It doesn't go through probate, which is true. It does, however, get counted for estate taxes. So a lot of people have a significant amount of life insurance without realizing it. They may have work-provided life insurance, retirement accounts that also are not probate. They do not pass through the estate, but they are counted for tax purposes, and they're often significant sums of money. Real estate will often appreciate significantly and may have been gifted from another family member. So reaching that 675 is quite possible, and the tax after that, you're taxed on the amount over 675. So it's not if you have a 676,000 that you're paying tax on all of it. It's just on that 1,000 that goes above it. But and it's a varying tax rate, so I can't tell you exactly how much it is, but I usually go with an estimate of like 10 to 15% of the amount above it, 675, that will be taxed in New Jersey. And that's a significant amount of money, and it's really only paid if you don't have proper planning. Now, I made a note here also, your choice of beneficiaries may affect taxes. We spoke mostly about estate taxes, and that's what you hear most about, but there's also an issue of inheritance tax. Depending on the relation of the person to you determines whether or not they're paying inheritance tax on property that you leave them. There are different class of people, so there's A, B, I think it goes A, B, and D, for instance. But basically, your immediate family, your siblings, your parents, they won't pay any inheritance tax. Uncles and aunts do. Friends and unrelated people absolutely do. So if you are going to be planning an estate and giving property to these types of individuals, you want to plan, or at least be aware of what their inheritance tax may be, so you can try to plan for that. You don't want to give somebody something if you're giving it to them because it's meaningful, or even if it's because it's valuable, but have them have to sell it to pay the inheritance tax. You're defeating the purpose. A lot of times people will leave somebody a house, but the house has to be sold because there's inheritance tax or even estate tax that needs to be paid that wasn't planned for. And we'll talk about how to plan that when we discuss the insurance pieces a little bit later, but insurance doesn't necessarily always help because insurance is also an asset to the estate. So sometimes you're buying insurance, but you're also increasing the taxes, which is why you bought the insurance in the first place. So the key is in estate tax and inheritance tax are very, very significant issues that really need to be contemplated and examined before and during any estate planning. Now, here are some other options. I'm not going to go deeply into them. They're very, very significant. Could have a webinar itself on any one of these. Gifting is a very good way to reduce the value of your estate, which then reduces both the estate taxes, also reduces the risk of an inheritance tax. The flip side, and generally you can gift almost any amount that you want. The gifting limits are basically the same as the federal estate tax limits. People hear this thing about $10,000 a year, which is now $5,000 a year, and they think that's all you can gift, but you can actually gift into the millions. without any tax consequence for you or the person receiving it. The numbers that you hear, the 13.5 and things like that, are just if you give more than that in 1 year, you have to report it. You have to have a gift tax filing, but there's no gift tax burden because of it. But there's also issues if you gift certain amounts within a certain amount of time before you pass, they can be taken back and counted again into your estate. So you may gift your house to your children to take it out of your estate, but unfortunately, if you pass within a couple of years of that transfer, it may come back and you've really accomplished nothing with the planning that you thought you would. So another thing you want to talk to an attorney about before you start planning any kind of estate is gifting. And trusts, like I said, you could do a whole webinar on that. I have done webinars, and I think are on my website. I think I also have one coming up next month on trusts. Trusts are one of the best ways to plan an estate. It's the best way to avoid estate tax, inheritance tax, the cost of probate. The flip side is they're sophisticated. They take different types of planning. They also have some administrative and legal costs that are associated that you will be managing, while you're alive to better provide for your loved ones through your estate. But trusts are probably my favorite way to plan an estate and eliminate all of these concerns with people, while also giving you the right to determine what happens to your property without worrying about all the costs that sometimes get associated. All right. Name someone to take care of you if you become incapacitated. Like I was saying in the beginning, this is about planning for your life, not your death. And this not only is important from a personal standpoint, but there's also a lot of legal issues that you need to protect. So I usually recommend people consider both a power of attorney and a living will. Now, just simply a power of attorney is just as it sounds. You're giving somebody the power to act as your attorney. The healthcare directive is giving somebody the power to make decisions for your medical needs if you become unable. Now, there's a couple different documents that are associated with both of these. The power of attorneys there's two main kinds of powers of attorney. There is the durable and springing. The durable, which is the most common, is effective as soon as it's executed, and it lasts forever unless it's revoked. So it's durable. That's why it's called that. Then there's a springing power of attorney. That comes into effect if you become disabled or incapacitated. So it springs into effect. The healthcare directive usually will have two components to it. It will have a medical directive and a living will. The medical directive is the part that assigns the person who's going to be in charge of making your medical decisions for you. The living will have what type of decisions that person should be making for you. Like, do you want experimental surgery? Do you want painkillers? Do you want life support? Do you have religious issues that need to be considered? These will be set forth in the living will so that decisions are given to that person. One, so that you can ensure that they're being made the way that you'd like them to be. Two, you're taking the pressure off the person that you've appointed from having to make horrible decisions like continuing life support or not. So let's talk about just the basic requirements of these. A power of attorney will provide, like I said, the power to act as your attorney. It gives authority over financial, business, and other decisions. Very important, because what happens if you become trapped out of the country on a vacation? This allows people to pay your bills, make sure your mortgage and your car payments are made so that nothing happens to you. If you go into the hospital for a long period of time, you don't want to lose your property. The medical directive, again, indicates how you want somebody to act on your behalf. It's very important to have this because these decisions, they're often not discussed. Most people in your life probably don't know whether or not you want life support or how you feel about pain medications and things like that. And you certainly want them to know. But also having these documents in place eliminates the burden that would be imposed upon family or friends that would have to take care of it in the event of some tragedy. And that's what people don't realize. If you get into an accident and you're in a coma, not only does your family and friends have to deal with that horror at the time, But then if there's nobody that can make the right decisions or your documents aren't in place, they also may have to go to court, file papers, and ask for permission to be appointed. So not only are they dealing with this tragedy, now they have this heavy burden. They may have to get legal counsel, they may have to spend money, it may take some time, and it's such a burden to put on them at probably the worst time. Now let's talk about taking care of your children. And this is an issue that comes up. Obviously, my practice is divorce, family, and estate. So the crossover of these issues are quite common. A lot of people have things that they want to accomplish and certain things they're not really aware that they could do. So we're going to talk about them. All right, so first couple points. You can dictate the guardian of your children, which means who is going to take care of your children. Not their money, but the person. Well, and it's both, actually. You're choosing both. But the reason I highlight who the person is because a lot of people feel they have no say in a case where maybe they're separated parents or divorced parents, and they don't want the non-custodial parent, the other parent, to get custody of their child. They may or may not have a valid reason for it. Now, you can put into your will, especially if you're the custodial parent, who you would want to have physical custody of your child or children once you pass. And if it's not the other parent, you would be able to explain why that is. Now, that's not going to be dispositive of the issue because the other parent has a constitutional right to a relationship with his or her child, but it's a starting point because the court's ultimately going to have to decide what's in the child's best interest, as they do with all child-related issues. And you, if you're the custodial parent, and even if you're not, but it's stronger if you're the custodial parent, the court will consider your wishes to a great extent when determining what's going to be in your child's best interest. So at least it helps if you feel strongly that the other parent is not capable of caring for the children. Then there's also handling their finances. And these don't necessarily have to be the same people. They can be, but you may have people that are better parents and not sophisticated enough to handle finances, and vice versa. You may have, like your parents may be great for financial advice and money management, but they may not have the energy to deal with young children. So you want to consider having two different people do that. And you need to consider whether that's good or bad, because in some cases you don't want the people caring for your children have to be begging for money from somebody else. So it's a coin toss. You really need to look at both sides of that issue. And it's important to have what I call spare person. When I do estate planning, whenever I get to the point of any kind of fiduciary, whether it's for custody of your children, for their finances of a trust, child's trust, even the executors and fiduciaries of your estate, you always want to have a second or a third, because you don't know what's going to happen from the time that you sign your documents to the time that you pass or you need them, depending on what the nature of the document is. The people who you name may not be available. They may not be willing to serve in the capacity. So if you haven't named alternates or thirds places, then once again, your families will find themselves having to go to court and file papers and maybe have lawyers. It makes it a very difficult burden. And I usually recommend, when it comes to fiduciaries for your children, the topic that we're currently on, I usually recommend that you talk to the people that you're going to name to handle both their custody, their physical custody, and their finances, to make sure that they want that obligation, because it's a very large obligation. Most other parts of an estate plan, I do not recommend that you discuss it with the people who will benefit, or people maybe who won't even benefit from it, because I think it's sometimes better left unsaid. That's obviously going to vary by family, but most of the time it's something that is kept private. But I think custody of the children should really be discussed to make sure that you're getting people who are willing and able to do it. Let's talk just real quick on cremation or burial, your choice. And like I said, I threw this in here because you have the right to choose what's going to happen to you, and a lot of people don't really think about this too often, unless some do. Some of them know exactly what they want to do, but a lot of people don't think about it, or if they do know, they don't think to put it into their will, and now it becomes an issue that the family's fighting over. So, I mean, it's just the simple things that you want to, consider. Where do you want to be buried, whether you're being cremated or not? Um, what's to happen with the ashes if you're going to be cremated? How are you going to be buried if you're going to? You may even want to put specifics about the funeral and the services. You may want to put some idea or limits onto the expense. You may want to increase the expense and make sure that you go out with a party. But you have the right to address these issues, and you really should, because again, like my common theme throughout this is give as much information to as many people that are going to be involved so that they don't have to make these decisions. They're going through one of the worst times probably ever. And what the purpose of this is to make it as easy and gentle as possible. So next we're going to move on to what's kind of a, well, not kind of it, what is a very complicated aspect. And again, I'm only going to touch a little bit on this because this is kind of a basic webinar. I have other webinars on my website for our estate planning, and I have, like I said earlier, I have some more coming up, I think, next month. So I'm just going to touch on some basic points here. Life insurance can be used for a variety of purposes. One is to address the costs that your estate will have. So, you're going to have your final bills if you die, let's say, with credit cards or medical bills. You're going to have a funeral bill. Depending on what property you have, one is a question whether or not there's going to be sufficient assets to pay the bills. But two is also whether or not the assets themselves are available or liquid enough to pay a bill. Like I mentioned before, if you leave a house to somebody and you have medical bills that have to be paid, the house is going to be sold to pay the bills. So while they may get the remaining proceeds, they're not getting the house. And that may be very important to you in your plan. That may be the purpose of giving them the house as opposed to having it sold. So like basically, you get life insurance so that it protects your estate assets, and you can choose. For instance, even though what's important to remember here is life insurance is still an asset of your estate. So if you have an estate that's worth $675,000 and you're not going to have New Jersey estate tax, but you buy life insurance of $1 million to help give more money to your family and to pay your medical bills, that million is going to take you over, and now you're going to be in the taxable estate. So you have to balance those two issues. But more often than not, the insurance, because it's often inexpensive to get a good sum of it, it's usually often the largest asset to many people's estates, can be used. So if you have, for instance, a house that's worth $750,000 or $1 million, and you're going to have New Jersey estate tax, you may even have New Jersey inheritance tax, depending on who you're giving it to, purchasing a life insurance with enough proceeds to cover the increase in the tax will allow the person to actually receive the house. So quite more often than not, life insurance, being the biggest asset to an estate, is also used for payment of a lot of taxes and bills that would otherwise prevent you from giving your property in the manner that you would like to. Now, that's the end of this seminar. It's a little shorter than I anticipated. I hope I didn't rush through anything, but I am, like I said, going to take any questions that you may have. So just going to check, see if anybody listed any questions here. So what I have to do is open up a different screen, so I may not see everything that's going on. But if you have any questions, post them up. It's usually, I think, best to go to the portion in the under the, I guess try under the chat section. I thought there was a question portion, but I'm not seeing it as I'm pulling down my own. So if you have, I have both open. So if you want to post something in the chat or into the question section, feel free. Like I said, I'm here as long as you need me to. I don't see any. So what I'm going to do now is I'm going to just launch a couple polls and just ask a few questions. So if I could take a minute, get a better sense of who's here and why you're here, so I can plan for better ones in the future for you. So just give me a second. Let me. All right. So you should be seeing the first question. Now your responses are not going to be viewed by anybody individually. Nobody even knows that you're here. They can't see you. I may post the end result of the number, but that's just for stat purposes. All right, I think we got most answers. All right, so that helps me to know. Let's take a second one. We just have a few more, so I just got I think 3 or 4 more real quick. I don't know if this is a good time for people. Okay, and that seems to be mostly yes and some no. So I'll have to look at that because I certainly want to be able to accommodate people. Now let's see if anybody has taken my advice before coming today and actually has a plan in place. That's interesting. Okay, that's great. Actually, that's probably some of the highest numbers I've seen during a estate planning webinar, so good for you. This is most important for me. If your answer is no, please either post it or email to me. You should have received emails about the webinar, so you have my email address. All right, so I'm getting half and half, but I don't remember seeing any questions that were posed. So let me just double check, see if I missed any. So my chat panel is different than the ones I normally use, so I don't see any questions. All right, so for those who said I didn't, I apologize, and I'm not seeing any questions that are listed. So please feel free to email me anything that I did not address as soon as you have the ability, the time are able to. And my last question. This, I guess, would also be to the people specifically I didn't answer to. Okay, this one I'm not going to post, just by the nature of the question, even though you don't see the results. But those that are interested will certainly contact, or you can contact us, whichever works best for you. So that being said, I want to thank you all for attending. The next webinar is next month, May 26th. Trying to see if it's on divorce and domestic violence. Obviously, both topics are very emotional and difficult. If you or somebody that you know has these issues or may have these issues to deal with, certainly recommend that they attend. It's also good if you want to attend. That way you get the information yourself. You can also share with them. And with that, I want to wish you a good night and hope to see you next month. Good night.